Okay, let's just jump right in. So picture this. You're getting married, totally in love, planning everything. But did you know there's already a contract kind of being written in the background?
Yeah, it's a surprising thought for a lot of people.
Right. And it's not one you're writing, it's the state you live in. It's basically the state's default plan for all your stuff, your money, your house, even your debts, if things don't work out. Seriously, it's like a prenuptial agreement you didn't even agree to.
That's such a crucial point to start with because, people often think, oh, if I don't sign a prenup, there's just nothing. But that's really not how it works.
There's always something.
There's always something. The state has its rules, its standard operating procedure for dividing property, figuring out who pays what debt, maybe alimony. All that stuff kicks in automatically if a marriage ends, whether by divorce or, even death sometimes.
And nobody likes to think about divorce, but the reality in the US is that a lot of marriages do end. So leaving your whole financial life up to some generic plan lawmakers wrote ages ago, maybe not the smartest move.
Probably not. It's often a one-size-fits-none situation.
Exactly. So this deep dive, we're going to unpack that default plan, but more importantly, we want you to understand that you actually have the power to write your own plan. You can take control.
Precisely. We're looking at prenuptial agreements or prenups not as some gloomy prediction of failure, but really as a practical, proactive tool. It's about getting clarity, right? Setting expectations together.
Taking control.
Taking control of your financial future as a couple, and honestly, finding some real peace of mind.
We've dug through a whole bunch of sources for this. We're going to figure out, what is a prenup, really? Why are more couples actually talking about them now? What kind of surprising things can go in them? I heard even pets.
Oh yeah, we'll get to the fur babies. And also, importantly, what can't go in them. There are definite limits.
Okay, good to know. And maybe the most critical part. How do you make sure, if you do get one, it's actually, legit, that it holds up in court?
Yeah, enforceability is key. Otherwise, what's the point? And we also need to tackle the big elephant in the room.
The conversation itself.
The conversation. How on earth do you bring this up with the person you love without, killing the romance completely? The sources actually have some really good advice on that.
Yeah, that feels like the biggest hurdle, honestly. But okay, let's start with the basics. What exactly is a prenuptial agreement, definition-wise?
So think of it simply as a contract. It's a formal, written agreement that a couple makes before they get married.
Before. Key point.
Key point. Before the wedding. And it outlines how they're going to handle their financial lives. Mostly it focuses on what happens financially if the marriage ends through divorce or if one spouse passes away. But can also cover how money stuff works during the marriage, too.
So you're basically saying, hey, state laws, thanks, but no thanks. We've discussed it, and we're setting our own rules here.
That's exactly it. You're swapping out the state's default divorce laws, their standard inheritance rules, with your own personalized agreement. Without one, the state decides how assets get split, who might pay alimony, how much, all those big financial questions. A prenup lets you make those calls yourselves.
And this whole idea that prenups are just for, billionaires or people with massive trust funds, is that still the case? Or is it changing?
That's a really common misconception, and the sources are clear it's outdated.
Yeah.
It actually stops a lot of couples who could benefit from even thinking about it. Sure, they're useful for the super rich, but they're becoming way more relevant for, lots of regular people too.
Like who?
Think about people getting married for the second time. Maybe they have kids from a previous relationship.
Sure.
Or someone starting their own business. Or maybe you've got significant student loan debt coming into the marriage.
Okay.
Or even just couples who, want that clarity. They want a clear financial roadmap laid out from the start.
Right. So, okay, it's not just planning for the worst. What are some of the, positive reasons people are doing this? The sources mentioned quite a few benefits.
Yeah, and focusing on these positives can definitely make that tough conversation a bit easier. One of the biggest ones mentioned is forcing full financial disclosure, clarity.
You mean you have to show each other everything, bank accounts, debts, the whole picture?
Legally, yes. The process requires both people to lay out all their finances, assets, income, debts before signing. So no hidden credit card debt surprises, no secret inheritances lurking.
Okay, that actually sounds healthy. Starting off with total financial honesty.
It really is. It builds trust right from the beginning. Money issues are a huge source of stress in marriages. Getting everything out in the open avoids those painful discoveries later on.
And knowing everything helps you set clear expectations, I guess.
Absolutely. Once you see the whole picture, the prenup is where you write down your agreement on how things will be treated.
Yeah.
Like, okay, you own a condo before marriage. Is that staying yours no matter what? What about the money you both earn during the marriage? Is that pooled or kept separate? Getting it in writing avoids so many future fights based on assumptions.
It provides a sense of security, too, doesn't it? Almost like insurance.
That's a fantastic analogy, and one the sources use a lot. You get health insurance or car insurance hoping you never ever need it, right?
Right.
But you have it for peace of mind, just in case. A prenup is like financial insurance for the marriage. It protects both partners from potentially really bad financial outcomes if things go south. It stops that feeling of, oh my gosh, I could lose everything I work for, or, I could be left with nothing.
So it's not just about protecting the person with more money, it can protect the other person too.
Definitely. A well-drafted prenup can absolutely protect the spouse with fewer assets or lower income. It can guarantee them a certain amount of support or a specific share of assets, maybe more than state law would automatically give them in a messy divorce. It provides predictability.
And this leads to something the sources called communication practice, which sounds interesting.
It does, but it's maybe the most underrated benefit. Seriously, negotiating a prenup forces you as a couple to have really deep, sometimes really uncomfortable conversations about money, obviously, but also careers, future plans, debt, retirement.
The big stuff.
The really big stuff. And those what-if scenarios, divorce, illness, death. Having to navigate those tough talks together honestly and vulnerably, that builds incredibly strong communication skills. It's like a boot camp for handling difficult issues as a team later on.
If you can survive the prenup talk, maybe you can survive anything.
There might be some truth to that. It demands a level of teamwork and honesty many couples just don't get to until, a crisis hits. And for people entering a second marriage, especially with kids involved, a prenup is almost a must-have.
Why specifically? To protect the kid's inheritance.
That's a huge part of it, yes. It's a powerful way to reassure everyone and protect children from a previous relationship financially. You can clearly state that certain assets, or maybe an expected inheritance, are separate and will go to those kids, preventing ugly legal fights or accidentally disinheriting them later. It basically syncs up your marriage plan with your estate plan for your existing family.
And you even said it helps plan for the future during the marriage, not just the end.
Right. While the focus is often on what if it ends, the process itself makes you talk about the future. Are we having kids? How will that affect careers and money? Are we starting a business? When do we want to retire? The prenup discussion can actually spark creating a shared vision for those major life milestones.
Okay, I have to ask about the pets thing again. You can really put Fido's future in a legal contract.
Believe it or not, yes. Courts mainly deal with money. But if you both agree, you can include clauses about who gets custody and care of the family pets if you split up. Your fur babies, as you call them.
Wow.
Again, it's just about tackling potential arguments up front by agreeing on a solution together.
Okay, so the benefits are actually pretty broad, much wider than just protecting a fortune. Let's get into the nitty-gritty now. What are the most common clauses? What do people actually put in these things?
Okay, number one, overwhelmingly, is property division. This is the core. Who gets what if the marriage dissolves? And to do that, you have to distinguish between two key types of property.
Which are?
Separate property and marital or community property. This distinction is fundamental, both in prenups and under state default law.
Okay, break that down. Separate is?
Separate property is generally stuff you own before the wedding. Plus, usually anything you alone receive as a gift or inheritance during the marriage, if, and this is a big if, you keep it totally separate, don't mix it with joint funds.
And marital or community property?
That's basically everything else acquired by either of you during the marriage, using income earned during the marriage. Think salaries, things bought with those salaries, retirement funds built up during the marriage, that kind of stuff.
And without a prenup, the state has its own way of splitting that marital community pie, right?
Exactly. There are two main systems in the U.S. You've got 9 community property states. Think California, Texas, Arizona, places like that. There, marital property is generally seen as owned 50-50 and gets split down the middle.
And the rest?
The other 41 states use equitable distribution. Equitable means fair, but not necessarily equal. A judge divides the marital property based on various factors, contributions, earning potential, length of marriage. It could be 50-50, but it might not be.
So the property clause in a prenup lets you say, nope, we're not doing the state's 50-50 or equitable thing. We're doing this instead.
Precisely. You can customize it completely. You could agree that certain assets, even if acquired during marriage, remain separate. Or you can set a totally different division percentage. Maybe all income earned stays separate property of the person who earned it. Or maybe a specific house bought during the marriage belongs only to one spouse. It covers everything: houses, bank accounts, investments, businesses, cars, even like valuable collections.
Okay. What's next? Alimony or spousal support? That's another big one people worry about.
Huge one. Alimony, sometimes called spousal support or maintenance, is money paid by one ex-spouse to the other after divorce. It often comes up when there's a big income difference or if one spouse gave up their career, maybe to raise kids.
And lots of people either fear having to pay it or fear not getting it if they need it.
Exactly. There's anxiety on both sides. And a prenup is a very common way to address this head on.
How? Can you just say no alimony ever?
You can. A prenup can include a clause where one or both spouses completely waive their right to receive alimony. Or you can set limits. Maybe alimony is payable, but only up to a certain dollar amount, or only for a specific number of years. Or you can define conditions under which it would or wouldn't be paid. It adds predictability.
Debt. That seems just as important. People bring debt in, they rack it up during.
Absolutely critical. A debt division clause makes it clear who owns what debt. You can specify that your premarital student loans, for example, stay your responsibility alone. And crucially, you can dictate how debts taken on during the marriage are handled. This can protect you if your spouse takes out huge business loans or, runs up massive credit card debt in their name only.
Going back to inheritances for a sec, you mentioned my rich Uncle Bob.
Right, imaginary Uncle Bob.
If I want to make absolutely sure his generous checks stay mine, the prenup helps.
Yes, an inheritance clause is key for that. While state law often treats inheritances as separate property initially, that protection can vanish if you, say, deposit Uncle Bob's check into your joint checking account and use it for bills. That's called commingling. Mixes funds. A prenup can explicitly state that any inheritance received by either spouse remains their separate property. End of story, even if it accidentally gets mixed with marital funds. It's a much stronger shield against those commingling arguments.
What about gifts, like wedding gifts or big birthday presents between spouses?
Good question. Gifts are another thing a prenup can clarify. It can spell out whether gifts between the spouses during the marriage are considered joint property or stay the separate property of the person who received them. Think like an expensive engagement ring. One source used a $100K example, or maybe valuable anniversary gifts.
Okay.
It could also address how wedding gifts, often given to the couple jointly, should be handled if there's a split, or even regular gifts from family, like if your mom gives you a $10K check every Christmas. A prenup removes the ambiguity.
Let's talk about the harder stuff again, death. How does a prenup fit with wills and estate planning?
This is super important, but with a major caveat. A prenup is not a will or a trust. It doesn't replace a proper estate plan. It can't name guardians for kids or handle complex distributions.
Oh, it's a supplement then.
Exactly. It's a powerful complement to your estate plan. Its main role here is letting spouses waive certain inheritance rights they'd otherwise have under state law when their partner dies.
What kind of rights are we talking about?
So many states give a surviving spouse an elective share. This means even if the deceased spouse's will leaves them nothing, the survivor can still claim a chunk of the estate, often like a third or even half.
Wow, even if the will says otherwise.
Yep. It's protection for surviving spouses. But a prenup can include a clause where both spouses agree to waive this elective share right. This ensures their individual wills or trusts actually control where their assets go, which is crucial if you want to leave property to kids from a prior marriage or other family members instead of your current spouse.
So it basically guarantees your will's instructions for your separate stuff will be followed.
Precisely. It lines up the marriage contract with your estate goals. It provides certainty, especially for blended families or people with significant separate assets. You could even put in a clause requiring each spouse to get a will that matches the prenup's terms.
You also mentioned prenups can cover finances during the marriage, not just if it ends. How does that work?
Yeah, it's less common than the divorce death stuff, but definitely possible. A prenup can actually set rules for how you manage money while you're married. Like will you have joint bank accounts, separate ones, or some kind of mix? If you have joint accounts, how do deposits work? Who can withdraw? How would that joint money be split if you did divorce? It sets up a financial framework for your day-to-day life.
Could prevent some arguments down the road, maybe.
Could definitely help manage expectations around spending, saving, investing, all that.
And the house, the marital home, often the biggest asset.
Always a hot topic. The prenup spells out how the primary residence is treated. If one person owned it beforehand, it can confirm it stays separate property, though you'd need to address how things like mortgage payments made with marital funds are handled. But a really important point, one source used a great example of Julie and John, a stay-at-home parent and a breadwinner.
Okay.
The prenup can include a clause allowing one spouse, often the one with the kids, to stay in the house for a certain period after a divorce, even if the other spouse technically owns it. That provides really critical stability for the family during a tough transition.
Okay, wow. Prenups seem like they can cover a lot of ground, really detailed financial planning. But all those clauses, all that planning, it doesn't mean anything if the agreement itself isn't legally solid, right? If a judge can just toss it out.
Bingo. That's the crucial part. A prenup is a contract, plain and simple. And like any contract, it has to follow specific legal rules to be valid and enforceable. If you mess up these requirements, a judge could say, nope, this part's invalid, or even throw out the whole thing. And then you're right back to those default state laws you try to avoid.
Okay, so what are the absolute must-haves, the deal breakers that make a prenup legally sound?
These specifics can vary a little state by state, but there are core rules that are pretty much universal. Rule number one. It absolutely must be in writing.
No handshake deals.
No handshake deals. No verbal agreements. You need a physical document signed by both people, period.
Okay, written down. Check. What else?
It has to be signed voluntarily. This is huge. Both people have to agree to it freely. No duress, no coercion, no fraud, no manipulation. You can't trick someone, force them, or have them sign when they're, drunk or otherwise unable to understand what they're doing.
What about that classic scenario? The wedding's next week, invitations are out, family's flying in, and then the prenup appears. Does feeling pressured count as not voluntary?
That's exactly where voluntariness gets challenged all the time. Now, just feeling stressed because the wedding is close usually isn't enough, legally speaking, to prove duress on its own. But signing it really close to the wedding, that's a massive red flag for courts.
How close is too close?
Signing it literally on the way to the ceremony.
Yeah.
Big problem. Signing it a week before, risky. 2 weeks, still potentially dicey. Most lawyers strongly advise getting it finalized months in advance. That gives both people plenty of time to read it, understand it, get independent legal advice, and not feel like they're signing under the gun of the wedding date. Some states, like California, actually mandate a 7-day waiting period between seeing the final version and signing it.
Okay, so time equals less pressure, which equals more voluntary. Makes sense. What's next?
Financial disclosure. This is non-negotiable pretty much everywhere. Both partners must give each other a reasonably accurate picture of their financial situation, assets, income, debts before signing.
How detailed does it have to be? Like every single dollar?
Depends on the state. Some require full disclosure, meaning pretty much everything. Others use a fair disclosure standard, meaning enough info so the other person gets the general picture and understands what they're agreeing to. Often this involves attaching financial statements as exhibits to the prenup itself.
And if you don't disclose properly or hide something,
that can absolutely be grounds to invalidate the prenup later, especially if hiding assets makes the final agreement seem wildly unfair or unconscionable.
There's that word again, unconscionable. What does that mean practically? Like really unfair.
Extremely unfair. So unfair, it basically shocks the conscience of the court. Think of an agreement where, after a 20-year marriage, one person gets literally nothing, no assets, no support, while the other keeps millions. That's likely unconscionable. Courts generally won't enforce deals that leave one person totally destitute, especially through issues with disclosure or lack of legal advice. And some states look at fairness not just when it was signed, but also when it's being enforced years later. Things might have changed dramatically.
Okay, so it has to be fair then, and maybe fair now. Complex. What about the actual signing? Any special rules?
Yep, proper execution according to state law. Both parties have to sign it themselves. Your lawyer can't sign for you. And often, signatures need to be notarized. Some states even require witnesses, just like signing a will, especially if the prenup affects inheritance rights. Florida, for instance, is really specific. If you're waiving rights you'd have, as a surviving spouse, you need 2 witnesses and a notary, just like a will. You got to follow those state-specific formalities.
Okay, so written, voluntary, full disclosure, not crazy unfair, signed correctly, maybe notarized or witnessed. That's quite a checklist.
It is, and that's precisely why getting legal help is honestly the single most crucial step.
You mean lawyers?
Plural.
Yes, plural. Working with experienced family law attorneys is the absolute best way to make sure your prenup is drafted correctly, covers all the bases for your state, and has the best chance of holding up if it's ever challenged. And critically, this is super important. It's strongly recommended, and sometimes legally required, that each person has their own independent lawyer.
Why separate lawyers? Can't one lawyer just be neutral and help both people?
Nope, absolutely not. A lawyer's ethical duty is to fiercely advocate for their client's best interests. And in a prenup negotiation, what's best for one future spouse might be the opposite of what's best for the other, especially if there's a big difference in assets or income.
Independent lawyers advise each person separately. They explain what rights you'd have without the prenup under state law. They explain exactly how the prenup changes those rights. They make sure disclosure is adequate. They negotiate terms. They review the final draft for fairness from their client's perspective. Without that separate advice, one person might sign away crucial rights without fully understanding it. And that's a classic reason courts throw prenups out.
So those DIY prenup websites or templates, probably a bad idea.
Extremely risky. Same with having one lawyer try to represent both sides. You're just begging for trouble down the road.
What are some other common mistakes people make that can wreck a prenup?
Well, besides the big ones, lack of voluntariness, bad disclosure, no independent lawyers making the agreement incredibly one-sided or unconscionable is a killer. Another big mistake is not thinking about the future properly. Like, how will income earned during the marriage be treated? How about assets bought later? People sometimes think prenups only protect premarital stuff, but a good one can define how future earnings and assets are handled too, but it needs careful drafting.
So if someone's a student now but expects to earn a lot later, the prenup could address that future income.
Potentially, yes, depending on state law and how it's written. Also, just avoiding the tough conversations during the negotiation can backfire. If one person feels steamrolled or like their concerns weren't heard, they might later claim they didn't really agree voluntarily. And finally, putting stuff in the prenup that's just plain illegal or against public policy, that's a surefire way to get at least part of it invalidated.
Okay, that's a perfect segue. What things absolutely cannot go into a prenup, no matter what?
Right, there are definite no-go zones where courts won't let a private contract interfere with state law or public policy, especially if it affects kids. The number one forbidden topic, almost everywhere, is anything about children.
You mean like deciding child custody in advance, or setting child support amounts?
Exactly. You cannot do that in a prenup. Custody and child support are decided by a judge based on the child's best interests at the time of the divorce or separation. You can't predict what that will be years down the line, and parents can't make a deal that a court might later find harmful to the child. That power stays firmly with the court.
That makes total sense. The kid's welfare has to come first. What else is off limits?
Well, you can't include anything that requires or encourages illegal acts, obviously. And clauses that seem designed purely to incentivize divorce can be problematic, like a huge bonus payment to one spouse only if they file for divorce within 5 years. A court might see that as undermining the marriage itself and refuse to enforce it.
What about all those personal things people joke about, like who has to do the dishes? Or clauses about cheating?
Generally, courts really don't want to get involved in enforcing purely personal or lifestyle agreements. So clauses about chores, where you spend holidays, raising kids in a certain religion, that stuff usually isn't enforceable through the prenup. A judge might consider a religious upbringing agreement in a custody case, but the prenup itself doesn't enforce it. And those infidelity clauses or no cheating penalties, very tricky territory.
Why tricky?
Some states see them as purely punitive, like trying to punish bad behavior, which courts don't like doing in contract law. They might also see it as against public policy, including one could risk invalidating more than just that clause. California, for example, is known for being very strict against enforcing punitive infidelity clauses.
So bottom line, stick to the money stuff.
Pretty much. Prenups are strongest and most reliable when they focus on assets, debts, income, property division, and financial support. Trying to regulate personal behavior or non-financial aspects is usually ineffective and can even put the whole agreement at risk. Demanding your spouse practice the tuba for an hour every day, a judge isn't going to enforce that.
We've mentioned state differences quite a bit. Just how different are the laws, and why does it matter so much which state you're in?
The differences can be huge, and they matter immensely. The laws of the state where you get married, where you live during the marriage, or where you might eventually divorce can all impact how your prenup is viewed and whether it holds up. Now, there was an effort to create some consistency with something called the Uniform Premarital Agreement Act, or UPAA.
Okay.
which about 28 states and D.C. adopted it in some form. But even with that, states have made their own tweaks, and there are still major variations.
Like the basic way property is divided, community property versus equitable distribution.
Exactly. That's a fundamental difference. A prenup designed for a 50-50 community property state needs different language than one for an equitable distribution state where the judge has more flexibility. And if you get a prenup in, say, New York, equitable distribution, later divorce in California, community property, the California court might apply its own laws and interpret your agreement differently or have different rules for enforceability.
So if you think you might move states during the marriage, that's a big deal for the prenup.
Huge deal. A smart prenup will include what's called a choice of law clause. This basically says, we agree that the laws of X state will govern this agreement no matter where we live or divorce later. It adds a layer of predictability, though it's not always foolproof.
What other kinds of state variations pop up?
We touched on disclosure. Some states are stricter than others. The rules on needing independent lawyers very strongly recommended sometimes, legally required for certain things, like limiting alimony in California, other times. Time limits differ too. California's 7-day rule is very specific. Other states just say sufficient time, leaving it vague.
Can prenups expire automatically in some states?
They used to sometimes under older laws, so-called sunset provisions. But in most states that follow the UPAA framework now, a prenup lasts indefinitely, unless you specifically write an expiration date or condition into the agreement itself. Like this agreement terminates after 15 years, or maybe upon having kids, though that's less common and needs careful drafting.
And you mentioned courts sometimes stepping in, even with a waiver, like with alimony.
Right. Some states, like North Dakota and Florida, have laws allowing a judge to override an alimony waiver if enforcing it would leave one spouse so destitute they'd need public assistance. So even a clear waiver isn't always absolute, depending on the state. And those specific formalities for signing, like Florida, needing witnesses for waiving surviving spouse rights, totally state-specific. Miss those details, and that part of the prenup could fail.
Wow. Okay, so clearly grabbing a generic prenup template off the internet is a terrible idea.
Terrible, terrible idea. You're just setting yourself up for an expensive legal battle later to find out if it's even worth the paper it's written on. You need advice tailored to your situation and your state's laws.
How do prenups interact with other parts of your legal or financial life? Like we mentioned estate planning, but what about immigration, things like that?
Yeah, they don't exist in a vacuum. We covered the estate planning link. They supplement wills and trusts, help align property division with inheritance goals, especially letting spouses waive those elective share rights, critical for blended families.
And you mentioned postnups earlier.
Right. Postnuptial agreements are basically the same idea, but signed after you're already married. Maybe you didn't get a prenup and now circumstances have changed, or you want to clarify finances, or maybe you modify an existing prenup. Separation agreements signed when divorce is happening are technically a type of postnup too.
Okay. Now, immigration sponsorship, that seems like a really different world. How does a prenup connect there?
It's a really important connection that often gets overlooked. When a U.S. citizen sponsors their immigrant spouse for a green card, they have to sign a specific form, the I-864 Affidavit of Support. This is a serious contract with the U.S. government.
What does it promise?
The sponsor promises to financially support the immigrant spouse at a certain level, 125% of the poverty line, until the spouse becomes a citizen, works for about 10 years, or other specific events happen. And here's the kicker. This obligation survives divorce.
Wow. So even if you divorce, the U.S. citizen sponsor is still legally on the hook to support the immigrant ex-spouse.
Correct. So if you have a prenup where the immigrant spouse waived alimony, that waiver cannot violate the I-864 obligation. If enforcing the prenup's alimony waiver would leave the immigrant spouse needing support below that I-864 level, a court might say the prenup waiver is unenforceable, at least up to the amount required by the I-864. It's a clash between contract law and federal immigration law. Needs careful handling.
Good to know. What about student loans? So many people have them now.
Yeah, huge issue. Generally, student loans, especially federal ones, are considered the separate debt of the person who took them out. They aren't easily transferred, usually discharged on death. State law often reflects this anyway, but a prenup can explicitly state that all student debt remains the sole responsibility of the borrower spouse. Just makes it crystal clear.
And professional degrees, like a doctor's license or a law degree earned during the marriage. Are those assets the prenup can divide?
Oof. That's a really complex and state-specific question. Some states might treat a professional license or a degree earned during marriage as a marital asset, or at least factor its value into property division or alimony. Other states absolutely do not. So could a prenup try to define how that degree or the resulting future income is treated? Maybe. But whether that clause would actually be enforced depends heavily on that specific state's laws on the topic. Very tricky.
Okay. We have covered so much ground here. The why, the what, the how to make it legal, the what not to do, the state stuff. It all seems pretty logical, on paper. But let's circle back to the really human part. Asking the person you're about to marry to sign a legal document about what happens if you divorce, that's got to be where most people just freeze. Why is that conversation so hard?
Oh, it cuts right to the heart of things, doesn't it? It bumps up against all our romantic ideals. Love conquers all, marriage is forever, total trust. Bringing in lawyers and contracts about splitting up can feel like you're, poisoning the well.
Yeah, like you're planning for failure before you even start.
Exactly. It forces you to stare that possibility in the face, even if you think it'll never happen to you. And of course, it can easily be misinterpreted.
Like, you don't trust me, or you think I'm just after your money.
Absolutely. That's often the immediate reaction. It can trigger defensiveness, hurt, resentment, and it also shines a big spotlight on any financial differences between the couple, which can make the partner with less money feel insecure or judged.
And then maybe family and friends chime in with their opinions.
Oh, that definitely doesn't help. Everyone's got a story or advice, usually based on their own baggage. It turns a really personal couple decision into this public debate sometimes.
Okay, so it's a minefield. Given all that, how do you even start this conversation sensitively? How do you try to make it not blow up?
The sources give some really solid advice here. First off, timing and setting are everything. Do not spring this on someone casually or when you're stressed or like right after getting engaged or worse, near the wedding date. Pick a calm, private moment well before any concrete wedding plans are locked in. Months before. This shows it's a thoughtful consideration, not some last-minute ambush.
Months. Got it. Give space.
Tons of space. Second, how you frame it is absolutely critical. Don't lead with, I need to protect my assets if we divorce. That's a disaster.
So what do you say?
Frame it as a positive, responsible step for the relationship. Talk about the benefits we discussed. Clarity, managing expectations together, financial planning, security for both of you. Talk about building a strong financial foundation together.
Use we and us, not me and mine.
Yes, exactly. We should figure out a plan that works for both of us. Let's talk about how we want to manage things financially as a team. And then be prepared to listen. Your partner might be surprised, hurt, angry, scared. Validate those feelings.
Like, I get that this is hard to talk about.
Perfect. I understand you might feel hurt, and I want to talk through that. Create a safe space for their reaction. Be honest about your reasons too, but gently. If it's about protecting kids from a prior marriage, say that. If it's about a family business, explain why that needs clarity. If it's about debt, explain you don't want to burden them. Transparency helps.
And it can't be just one person laying down the law, right? It has to be a negotiation.
Absolutely essential. It's a two-way street. Encourage your partner to think about what they want clarified or protected. It should feel collaborative, like you're building something together, not like one person is imposing terms on the other. And definitely avoid ultimatums. Sign this or there's no wedding is relationship poison, and it could make the prenup unenforceable due to coercion anyway.
What about involving lawyers? Can that help, or does it just escalate things?
It can actually help if done right. Maybe suggest meeting with a neutral lawyer together first, just for an informational session about what prenups are and how they work in your state. That can demystify it. Then emphasize that both of you will need your own independent lawyers to advise you before anything is signed. Framing it as standard legal procedure, not an accusation, is key.
But what if, even with the best approach, your partner just reacts really badly, gets angry, shuts down?
First, try to stay calm yourself. Don't get defensive. Reiterate your love and commitment. Gently bring it back to planning and security for both of you, not distrust. If they shut down, maybe suggest pausing the conversation and coming back to it later. Give them time to process. If they're angry, acknowledge it. I see this is upsetting you. And maybe suggest that having clear rules could actually prevent future money fights. If the issue is financial inequality, that's where working with separate lawyers is crucial to ensure the agreement is fair, and maybe includes provisions that specifically address the less wealthy partner's security.
It really sounds like navigating the emotional side is almost more important than the legal drafting itself.
It really is. If you can get through this conversation with honesty, empathy, and compromise, it actually says a lot about the strength of your relationship and your ability to tackle tough things together down the road. It's a real test, but it can ultimately be strengthening.
Wow. Okay, we've definitely gone deep into the world of US prenuptial agreements today. We've unpacked what they really are, basically. You writing your own financial rules instead of using the state's default plan.
Yeah, and we looked at the huge range of things they can cover: property, debt, alimony, inheritances, gifts, even how you handle money day to day, and yes, even pet custody. We saw they're not just for the super rich anymore, but a tool for any couple wanting that financial clarity and control.
And we got into the really critical stuff about making them legally enforceable, being in writing, signed voluntarily, with full disclosure, being fair, following state rules, and that huge point about both people needing their own lawyers.
Plus what you can't put in them, like child custody, and how much state laws vary, making expert advice so important.
And finally, we tackled that really tough emotional piece, how to actually talk about this sensitive topic in a way that's productive, not destructive.
I think the key takeaway, really, is that a prenup is fundamentally about being proactive. It's about communication, planning together, creating that roadmap for the what-ifs, and giving both partners a sense of security and understanding about their financial lives.
It's about making conscious choices about your future together, based on your specific situation, instead of just letting the state's generic rules apply. It's about taking the power back, in a way.
Exactly. Intentional financial partnership.
So here's a final thought, maybe a provocative one for you to chew on. What if we stopped thinking about prenups as predicting failure or signaling distrust? What if instead we saw the act of having these difficult, honest conversations about money, about the future, about potential vulnerabilities? What if that process, that collaborative effort to build a fair plan, is actually one of the strongest foundations you can build for a lasting, resilient marriage?
That's a powerful reframe. Seeing the conversation itself as an investment in the relationship's strength. An act of trust, not suspicion.
Something to think about. Well, that wraps up this deep dive.
Thanks for digging into this with us. It's complex, but hopefully this sheds some light.
We really hope so. We'll catch you next time for another deep dive into a whole new set of sources.